Good evening, Assalamu alaikum rahmatullahi wa barakatuh, and welcome back to Hilaal Live. My name is Faraz Patel. We'd like to thank you, the viewer, for staying with us. I also like to thank my colleague Luqman Shadrach for taking you through that first part of the show. Now, of course, tomorrow and the news that continues to revive South Africans, and of course, looking ahead to that court case, the International Court of Justice tomorrow, saying that it will announce its emergency measures against Israel after South Africa filed that case accusing Israel of genocide in its assault on Gaza. The ICJ will not deal with the main question of whether Israel is committing genocide, but will look at possible emergency measures requested by South Africa to restrain Israel's actions. Joining us now to discuss this, I'd like to welcome Jo Bluen, who is studying her PhD in international law at the London School of Economics, and she's also part of the South African Jews for a Free Palestine. Jo, good evening. Thank you so much for joining us.
Good evening, Faraz, and good evening to your listeners. Thank you for having me on the show.
No, it's an absolute pleasure. Jo, let's start off, of course, when you look at that presentation that was given by the South African legal team. It was convincing in so many ways, wasn't it? That it received praise from practically every single corner of the globe. And I say practically, at least 90%. Of course, there were a few countries that objected to it, but it was that convincing, wasn't it?
It was absolutely convincing. You know, the South African legal team really outdid itself. I think not only in first of all, situating, the current genocide in Gaza within the context of the ongoing Nakba of 75 years of apartheid occupation in Palestine, but also on some of the kind of sticky legal questions. So, for example, genocidal intent, which is one of the more tricky spaces in international law to prove. But by linking genocidal rhetoric to actions of soldiers on the ground, by linking this to evacuations as genocidal acts in kind of preempting the Israeli argument, the South African team really has an airtight case, and it's very clear to see, and we've seen, of course, support from those who recognize genocide, over Herero and Nama, traditional leaders, Namibia, many states. But very much you can see the detractors are those states that really wish to stand on the side of settler colonization and Zionism, rather than having any real legal arguments against the truly elastic and inventive and carefully archived case.
Jo, again, convincing evidence, compelling evidence presented by the South African legal team. But this is not one on a court of public opinion. It's one based on facts, and that is the reality of with anything that is presented in a court. Surely the evidence presented by the SA legal team should be enough for the ICJ to, of course, first, put a stop to what the Israeli army is doing in Gaza right now. But can that be the case? Because there's a sense of concern that they may rule against the South African legal team. I mean, what's your take on it? Where do you think the ruling for South Africa could be won in that regard?
It's a great question, and one that I'm always a bit hesitant to answer, but it's a very good question, no less. So I think the first point is that South Africa, the team, very strategically, and as was done in the case of the Gambia versus Myanmar, has not it's a request for provisional measures. So at this stage, the court doesn't actually have to rule on the merits of whether genocide is being committed or not. They have to make an assessment on the basis of the evidence presented by both parties about whether provisional measures such as a ceasefire, such as the delivery of humanitarian aid, et cetera, the kind of steps to prevent genocide. I believe they cited the Myanmar, the Gambia versus Myanmar case, where there's a particular utility for provisional measures if there is urgency, in a sense that there is a real and imminent risk that irreparable prejudice will be caused before the court gives a final decision. Sorry, I'm just reading from the case there.
Sure.
So that is what is being sought. Now, on the basis of the facts presented, I mean, I'd like to say 2 points about that. First of all, you're absolutely right that if you look at the archive, if you look at the record, the use of international humanitarian sources, of international NGO sources, of Palestinian sources, of multiple openly available sources that they have put together, it is meticulous. So on the facts alone, we don't have to doubt that. And I think the second point, and I think to your point about public opinion, whatever happens, it's already happened. You know, we know that there is genocide. It's very clear to those of us who are watching the news, who are following on social media. It is not happening. It's not being concealed. So what the South African case has done is really just provided a very clear legal archive of this.
Joe, of course, you know, being in the media, you have to listen to two sides. We listened to the Israeli side. A lot of the times the word Hamas was used. But then, of course, they brought about that what happened on October the 7th has further extended, in their words, the rise of anti-Semitism. Are those plausible facts that could weigh in favor of Israel, given those two, well, in their words, strong points that they brought up during their presentation?
You know, I think the first of all, the kind of one of the things I appreciate about the South African contextualization specifically is that this is the events of October 7th, which are clearly spoken about in the text, but are placed in the context of ongoing apartheid. And I think that is very key, that this did not start on October 7th, that this started in 1948, or we can go back to the Balfour Declaration of 1917, and the ongoing genocidal ethnic cleansing, Nakba, and apartheid in Palestine is number one. So I think that kind of the historic, you know, we call it the legal temporality, the legal sense of time, which cuts off certain time benchmarks to make possible the impunity for colonial war crimes. And this is a very strong feature of international law. And Israel was very clearly tapping into this. On the question of anti-Semitism, I think we do need to be very serious that there is rising anti-Semitism globally, as there is rising Islamophobia, as there are rising forms of racism of many types. Now, Zionism itself is a form of anti-Semitism, and Israel demands anti-Semitism in order to survive, to sustain the idea that there needs to be a homeland for the Jewish people, which is a very new idea in Jewish history and in the history of the world. Jews being a diasporic people that have lived comfortably amongst other people in all societies for millennia. You know, it needs to sustain this idea of a particular notion of anti-Semitism that really, as South African Jews for a free Palestine, we find very offensive. Many of us are deeply connected to our faith and our Judaism, and we stand up to all forms of prejudice and injustice, including anti-Semitism. And the conflation of anti-Zionism, the idea that Israel is not a legitimate state, and anti-Semitism, prejudice against Jews, is really, quite frankly, just a very dangerous ploy by Israel and Zionists, and we don't support it at all.
Joe, everyone's waited with bated breath because this is going to be the biggest litmus test, one of the biggest litmus tests in international law. The UN's under quite a massive magnifying glass, aren't they? Because they know now that any ruling that rules against any basic human rights will see the public really looking at international law as a complete farce, something that cannot be taken seriously. So really, this is as big a litmus test as they've ever had.
I have nothing to add, but I will. So I think you're 100% right. And if you look at, I think what's very significant is international law. If you look at the history, so my focus is on legal history. And if you look at the history of international law, here you have a system that historically has been used to legalize colonization, to legalize colonial genocide, to legalize racism in all its forms. And actually, so if we look, for example, at the Dutch East India Company, which, as we know, coming Jan van Riebeck coming on the boat 1652, and that history, the production of a penal colony in the Cape, all of this is part of Grotius, who is the forefather of modern international law, was an advisor to the Dutch East India Company that was complicit in the settlement of the Cape. And so what we're seeing is this history of the law being a deeply colonial, used to justify colonial genocide, coming up against the law being used to challenge colonial genocide. And what the question is at hand is whether international law is truly international. And I don't think that whatever happens, that the law will be a solution. I think it's one of many tactics in the struggle for Palestinian freedom and broader anti-colonial freedoms. But you're absolutely right that what is at stake here is not only international law, but the entire international architecture and what we understand by the term the human in human rights. Are we talking about humans as white humans, as Western humans, or are all humans, regardless of race, religion, creed, ability, sexuality, gender, also humans? And that is the question for human rights and the international system.
Jo, always a pleasure tapping into your knowledge. Much appreciated.
Thank you so much for having me, and have a great evening.
You also, that's Jo Bluen, studying a PhD in international law at the London School of Economics. She's also a representative of the South African Jews for a Free Palestine. Do stay tuned to Hilaal Live. We'll be back after this break.